licensed foster home for 6 months, that we monitor for 6 months. Not just in the home for 6 months, but monitor that license for 6 months. And the hard part is when they're getting that money from the being a foster parent, it's like double what your subsidy is going to be. And then they get mad, they're like, I'm cutting their paycheck. But they get the college at the end.
Yeah.
And they get the Medicaid.
Thank you very much.
I'm sorry.
That's all right. But there's candy on the table. We usually give candy, but we're trying to lighten it up. Mr.
My
Fulton,
popcorn
would you
dinner.
like to talk next?
Sure, let's Susan share.
I'm going to ask Susan to talk about the attorney ad litem as well,
Okay.
because my attorney ad litem canceled on me at the last minute.
Okay.
So let me introduce Mr. John Fultz. He's the county attorney for Grimes County. And what he's going to talk about is what it's like to be the county attorney in Burleson and in Grimes is CPS's attorney. And then Susan, if you don't mind, since you've been an attorney ad litem, I was going to ask you to talk a little bit about that
Sure.
too. Okay, so.
Yeah, her attorney ad litem didn't return her email.
So anyway, so thank you for being here.
Bye.
Bye, Melissa, thank you.
Huh?
Try not to talk as much as
Oh, I forgot to say good luck to all of you, and I look forward to working with you in my counties.
Thanks, Melissa.
The reason I wanted her to talk about that before she left was there are many times where we have young parents or maybe just one young parent, and that person's struggling with whether to make the decision whether I can do all of the things that are being asked of me, or I will relinquish and someone in my family or a fictive kin will get to adopt, and my kid will get all those benefits, and guess what? I'm not out of the picture. So I mean, it's a way to set up a scenario where the parent still gets to be involved in the kid's life. You don't know that, and you can't put that in writing, but in all likelihood, that's going to happen, especially when you see that they're working together. And you have those folks who are serving as foster parents oftentimes aren't coming into this, that a parent who's struggling or a parent who's just young and dumb and made a bunch of mistakes, they're never going to have any contact. Now, you don't know that for sure, but we sometimes at mediation will work things out that way because it just makes sense to get the benefits that you provide to your kid by getting this done. It's effectively a child support payment from the state. Now, I'm not real happy about that, I guess, if it's my money, but these kids need it. Okay, so I'll get off that soapbox. I'm glad she said swimming pool. There's one other thing I want to say before I go into my role. I have said that to Melissa and my caseworkers many times. It's not our job to give every kid a swimming pool, because there are those occasions that you feel like that's how you see it or that's what you want to do. And it is a tough call when you have a parent who is half-heartedly working the plan, but you don't have a lot of bad stuff to say about it. It's tough. I mean, it's really a tough call when you get to the end of it and you say, terminate or not. You know, as y'all were talking about earlier, there's a legal presumption in favor of parents. You get your kids unless you're bad for your kids. I mean, that's effectively what it is. And so we're going to trial on whether you're bad for your kids. And the question of what's bad for your kids is up to the judge or up to the jury. I mean, whatever you think, I bet, you know, there's 30, 40 people in here. Each of you have an idea of what that is. And we probably could build a consensus on that. But if I said, what's in the best interest of a child? What I think that is and what you think that is may be different. There is a case, and there are also statutes that talk about best interest, but they're pretty certain to say this is not an exclusive list, which basically means if it comes down to the judge or the jury deciding, it's whatever that person thinks. And Susan may talk about this, it's not all that important. We look at, when we're trying a case, we look at if this case goes up on appeal, can it be reversed or would it be reversed? Well, there are various standards, but the one in these cases is typically abuse of discretion, which means as long as the judge or the jury operated within these bounds and didn't go crazy and get out here, then it's going to stand. The likelihood of reversing that is slim to none. So once this decision is made at trial, it's highly likely that it's going to stick, is my point. All right, as she said, my name is John Fultz. I'm the county attorney for Grimes County. When I began in my position in 2005, my predecessor didn't take these cases. And I analyzed why that was. He was a great guy. He supported me in my campaign, so I sure wouldn't say anything bad about him. But he didn't take these cases because I think a couple of reasons. He wasn't familiar with them, and he had gotten used to the fact that a regional attorney would come down from Austin and handle them, and the pay wasn't the same that it is now, and I think there was a good justification there. There are some counties that continue to operate that way, the county attorney or whomever believes it, or sees that there's a statute that talks about county attorney or criminal district attorney, not all that important. You can say there are extraordinary circumstances, I think is the standard, and you can say, I need somebody from the regional office to come down and handle these cases. My perspective is that if they think you want to bow out, they're not looking to grill you. I said the regional attorneys are not looking to grill you as to what your circumstances are. They just show up if you want to get out. If you're not going to do it, we'll do it. Never seen a fight over who's going to do it, the local guy or the regional guy. I felt it, and not that I'm all that altruistic, but I felt like if I was going to have cases that involved parents in my community, it was appropriate to have somebody locally who kind of understood what the standard was. Whether beating a kid with a stick on the butt is okay or is not okay. All right? I mean, you get into those kind of questions. And of course, in care, you don't beat a kid with anything. But before that, there are a lot of a lot of parents spanking their kids with switches or whatever.
Belts, paddles.
Right, that's right. And I'm not, believe me, ask my son, I'm not the guy to stand here and tell you that that's not appropriate. So anyway, I just felt like it was appropriate for a local person to have eyes on a case rather than bring somebody in from Austin. And I love Austin, but bring somebody in from 1,000,000 miles away and make, their call about when you have discretion as an attorney. Now, having said that, the way that it works is like many clients. When a client comes to you, you're typically going to size up their case from the beginning and say, is this something that is repugnant to me, that I can't do? Most of the time, you're not going to say, this is a lying, cheating, sorry son of a gun, and I'm not going to represent you. So most of the time, you have a client come in, and it's a case you're familiar with, the type of case you're familiar with handling, you'll take it. So when it comes to CPS cases, when the case comes in, I don't have a whole lot of options as saying I'm out, but I do have a lot of options about saying how hard I beat on Melissa or beat on the caseworker about what direction I think this case ought to go. She left before I had a chance to say it, but there have been either one or two cases in whatever this is, 12 years, that they have wanted to try the case, and I have said, Melissa, I think this case is a loser. And there's some pride. I don't want to lose. I don't like to lose. But at the same time, what she explained to you all, it's tragic for the kid. It's tragic to go and have a loss and the kids return home and you have no ability to monitor. So in those cases, she and I have talked back and forth, and she has respected my judgment about not wanting to lose, which is fortunate, and we've worked those cases out. So she and I have always been on the same page, never had a real disagreement about how to see things. We've talked about her opinion and perspective versus mine. And that's the reason that I raised that question for you all to hear from her. There was a case that I can recall that we had in Grimes County where the CASA disagreed with what the department was recommending. And the CASA and I got crossways, and which is kind of silly because I'm just there as a stooge. Just know, I'm just a stooge for my client. That's it. I'm there to ask them questions, and if you ever come to court, you'll see me filling out blanks in an order. My secretary drafts the order, but there are a couple of places that have blanks. For instance, when is the next court date? So I'm there asking a series of questions that I have asked a gazillion times, and then I'm filling in blanks. I don't even get to see the kids unless they come to court. It's not my job. It's not my client is the one who has that job. It would be the same as in a private attorney role. It's not necessarily my job to go out and do the various things with or for my client when we have a case. Now, there would be other cases where you want to go out and do your own investigation. It's always seemed improper to me because, especially the number of folks we already have, because to me, it puts a further burden on a child, knowing somebody, meeting somebody, dealing with somebody else, etc., especially when it's me. I mean, they don't need to see me or meet me or whatever it may be. So I don't get involved with the kids. Oftentimes I'm reading out names and I couldn't tell you what they look like. Couldn't pick them out of a lineup or couldn't identify them from that. But that's where you guys come in. I mean, that's what you do. You're in the trenches with the kids, and you know them, and you know their birthdays, and you know their middle names, and you know sometimes what food they like and what toy they like and what the doctor says about them, what the counselor says about them. I was going to ask that question before, and I guess now I've given you a little bit of a hint. If I said you get to decide what's best for this child, what's the best interest of this child, let's say, how do you make that decision? How do you make that decision? How do you know what you're gonna tell the judge, what you think is best for the child? Well, oftentimes you have your supervisor telling you what you think, but you really are given some range, or given the reins to some degree to say what you think is appropriate for these kids. And I'll tell you how you know is you're in the trenches and you're seeing the kids and you're talking to the kids and you're talking to the counselor and you're talking to the doctor and you're seeing what they have to say. Now, you may very well say, based upon my own experience, I think this doctor's a quack, or the counselor, they know what they're talking about. And you certainly have the right to say that. And there have been circumstances, and I don't know if it's because what CASA has said, but there have been times where we've had to change counselors for kids because it's been deemed inappropriate for that kid to keep going to that counselor. So I'm not suggesting you go in and tear everything up and start anew, but I am saying that you're here to have your eyes open and use your heart and your brain and see what's going on with this kid and make your own determination as to what you believe is in the best interest of the kid. Now, of course, again, we have different perspectives on that. In most of these cases, we haven't probably had, and Susan, I don't know what your experience has been, but we haven't had a jury trial in probably 5 years.
I've had one this year, and I've got one the week before Christmas.
I'm sorry.
Yes.
Yeah.
Which has its own set of problems.
Yeah. Well, they're not fun. The last one had two. There were two that were close together. One was on special needs kids who had a special needs mom, and maybe the dad was special needs, but if nothing else, he was an angry guy. And man, that was tough. That was tough. The jury cried after it. It's just tough. It's tough on everybody. It's not fun. And so I say that to say to you that more frequently we have bench trials, but those are still fairly few and far between. On that note, I'm going to tell you a little bit about my judge in a second, but I love him to pieces. But he believes, just so you heard this, he believes that case law supports his position that drug use by parents alone is not endangerment.
This is Delaney?
No, this is in Grimes County. This is PK Ryder.
Okay, I'm sorry.
I love him to pieces. But he's told me that several times, and I've told him that I disagree, and we've researched the case law, and I feel pretty good that if it comes down to one of those cases, that we'll be able to prevail. But his opinion is, or his reading of the case law is, you have to show the use of drugs and a nexus as to how the kids were abused or neglected. They got high and endangered the kids. They got high and ignored the kids or neglected the kids. If you just show that they got high in the car and the kids were asleep, the kids never knew anything about it, he's going to say that's not enough. I understand his perspective. I get it. But the reality is, when you start digging behind it, you know, if they're using drugs, if people are using drugs, they're often spending money, oftentimes money they don't have to get drugs. And it adjusts their temperament and who they are with their kids. Either they need to get another fix or they're high. And if it's one of those things, it's going to affect how they parent. Now, for you, that is another occasion of eyes wide open. You need to see that. You need to identify that. I have told my workers that when they do their affidavit, they can't just phone it in. I mean, they've got to be serious when it's a meth case, and we see, if not every other case, you know, 3/4 of the cases are meth cases. And I've told them that you can't just put in there that mom, you know, tested positive for meth. You've got to show that somehow that affected the child. Otherwise, I mean, I'm going to have to grill you and pry that information out of you when we get to the adversary. You've got to put it in there so that I'll know what it is. Otherwise, I won't know what it is to ask you, and likely I won't ask you until the adversary. So if you know that and you see that, your eyes should be open. You should be spotting those things and identifying the change in the temperament of the parents, their ability to take care of the child, whether the child's endangered or neglected because of the drug use. You need to look for that and not just assume that tested positive, we've got a good case, let's go get a termination. That's highly unlikely to happen. All right, so my judge, he started, I guess, about, Susan, I don't know, maybe the time you stopped coming to Grimes County. I don't think it's
No, I've been in front of Ryder.
Okay, well, I don't know when he took over for Judge Otis, but maybe that's 5 years ago, something like that. Yeah, so he comes in, and I don't know this guy from Adam. I may have had one other case in my other life, I may have had another case with him on a private matter, but I don't know. He walks in and he sits on the bench and he enjoys telling a joke or stories before court begins. And I think he's trying to warm folks up, but I'm thinking to myself, these folks are facing termination of parental rights. I'm not really sure this is the best audience for your comedy routine. But whatever, it is what it is. Again, I love him to pieces. He comes in, sits on the bench, and one of the first things out of his mouth is, I don't believe the government has any place in families. I said, oh my God, do you know what bench you're on? You know, I mean, this is crazy. This is the guy that's going to be sitting on, every case is going to be the government involved in family. And on those occasions where I've had to argue to him at the adversary otherwise, I try to remind him, and I saw Melissa wrote it up here, I try to remind him, this all starts with a call. This all starts with a referral. He ain't out looking for cases. I mean, this is somebody else concerned on the street. Now, sometimes it's BS. Or sometimes it's somebody with an axe to grind, or sometimes it's somebody in a custody fight. I'll call on the other parent and I'll win the kid. Sometimes that's the case, but that hasn't been my experience. In 12 years, there was, I think, one case, there was 2 parents, but I don't even know that it was a BS matter. I think there was some legitimacy to it. So I don't see those, haven't seen those on a regular basis. So keep that in mind when you're looking at these cases, and you hear that in media all the time, or folks, I think, who don't really know what's going on. CPS is taking cases they shouldn't, and they won't take cases that they should. And from my experience, it is a referral comes in, and either they're going to FPSS and they're being dealt with on the way, let's try to agree to this, or, it's having some meeting and trying to get a resolution, a protection plan where the parties, the family all agree on, we won't leave this child unsupervised in this person's care, whatever it may be. Getting a case to the courthouse that I see is one of the last measures that I've seen, CPS try. Now, there are those times where you don't have time or the ability to do something short of filing a case. The child's being hidden, you don't know what's going on, the allegations are something severe. So there are those times where the case comes straight to me, but I've reminded the judge, and that's where, when he said to me about the government shouldn't be involved, I always take him at that word when we have an adversary or we have some other hearing in front of him, is I go back to that. Judge, I just want to remind you, we didn't get into this voluntarily necessarily. We got called. Somebody had a concern. And 9.5, 9.9 times out of 10, he'll listen to me. There's been one time he sent a kid home, but it was okay. It was all right. So when I get a call, or my office gets a call, and I'm told that there's been a removal, or we're going to make a removal, we're sending a petition over to you, it gets faxed to me with the affidavit. I examine the affidavit and determine whether or not there's endangerment set out in the affidavit. If there is, then I sign the petition. My secretary makes sure it gets filed. The matter then gets set for a hearing. Hopefully within the 14 days. There's been a time we had some concern that it had, might have to be extended because we didn't have a judge that was coming very often, or as often as we do now. But then we have the hearing. And at the hearing, it's the equivalent if you've ever seen a civil case, or people are fighting in a custody dispute or divorce dispute, you get temporary orders if you want them. You can have a temporary order here. Well, in these cases, at temporary orders, you're establishing, in let's say a divorce case, who's going to use the stuff while the thing's pending, all right, and where the kid's going to go while this thing's pending. Well, our temporary order is, does the kid stay in care? And so it's a decent hurdle. The adversary is for us to show endangerment. And as I said, if I can't see it in the affidavit and I have to pull it out of the witness, I'm probably going to be disappointed, and it's possible we may not have enough there. I used to have a worker, so please, if you're ever a CASA, don't do this to me. I used to have a worker who I would ask a question and she would say, well, we had real concerns. And I'd say, well, this is the judge and this is the time, and he's the only guy that needs to hear the concerns. So what are they? It's like pulling teeth. She got in the worker was in the habit of saying that this is information that I'm not releasing out to the world, and I certainly don't want to get in a fight with the parents about my perspective, to the point that we're standing in court, and the only guy that mattered, that needed to hear it, the arbiter, wasn't getting the information. And so, whatever you do, don't be that guy or that girl. You're there to tell the judge what you know. Now, I don't always know, because there's not a whole lot of meeting time between me and the CASA ahead of time. I don't always know what you will know. And so, many times, I will say, and it's, you know, it's the usual questions. State your name for the courts. My understanding, you're a volunteer with CASA. I know you've been here for the testimony this morning, and you've heard what the department's had to say. Is there anything additional or any comments that you want to make? And so I open it up. Now, you're not supposed to do that. Lawyers would say you're not supposed to do that. But you're an ad litem. You're a guardian ad litem. By golly, if somebody tries to shut you down, what are they hiding, right? So I'm not worried about that. I'll open this question. It calls for a narrative response, too wide open. But that's what, I do it on purpose to give the CASA the opportunity to say anything and everything the CASA wants to say. Now, on that note, it's not horribly important necessarily, but I have had lawyers tell me that you being appointed as a guardian ad litem, you're a quasi-expert, and you can testify to the basis for your decision, the basis for your opinion, even if it's hearsay. So you should never be afraid to say, well, the doctor said, or so-and-so told me, if that's the basis for your decision. Now, what you shouldn't say, for my benefit, or maybe the other side if you happen to be against this, is, well, I know this is hearsay, but don't do that. Just say what the answer is, all right? Because then you tip somebody off that you're about to say something that you're concerned about potentially the credibility of the source. So don't put that out there. Just say it like it is. Yes, sir.
In your experience, do parents, defense attorneys try to discredit CASA or trip them up, or are they usually on good behavior?
No, well, I would say this, that most everybody in the room defers to the fact that you guys are volunteers, and that you gotta be in, that you're potentially in this, the expectation is you're in this for the right reason. When you have a parent who's going down, who's potentially going to lose their children, their lawyer's job is to go out swinging. So if you say something that is against their interest, they're going to ask you questions about it. And so, I mean, it's the same thing with the attorney ad litem. I know you all have studied the role. The difference of the attorney ad litem is the kid's voice. And somewhere in between ages, 4 and 10, the kid has a voice that potentially you're supposed to represent. As an attorney, you're supposed to figure out when that is. When the kid doesn't have a voice, the guardian ad litem is supposed to be looking out for the best interest, and an attorney can also be appointed in that same role. So you can have one person serving those two roles if the kid doesn't really have a voice. But if the kid's saying, I want to do this, and there's the potential that's against the best interest, you got a real problem, and so you got to have two people involved. It used to always be the case, well, it's almost always the case in Grimes County, you had one person, one attorney appointed for both roles. And fortunately, there was seldom an issue that looked like a conflict. If ever there was, I think the judge may have appointed two different attorneys. This is before CASA was in Grimes County. So I would say to you that be prepared. Be prepared for that. And all that means is you really got to own your position. I really feel this. I really have studied. I really spent the time. I know you guys have an obligation under your grant to keep your hours and whatnot. When I hear the hours that some CASA has spent on the case, it makes me laugh, because having been a lawyer who represented kids, the lawyers who represent kids and even parents don't get paid a ton of money to do this, all right? Unless you're hired, you're not getting a bunch of money as a court-appointed lawyer. And you have to make a decision as to how much time you put in on this case that's well below your rate, and a case that's paying the bills. And it's good lawyers, there are good lawyers who put in the time. But when I hear the numbers that you guys have, having been on the other side, and I considered myself a good lawyer who cared about my kids and cared about my cases, you have far many more hours, far much more time than I ever had on cases. You know, I had somebody, maybe it was because we were up to a jury trial, somebody said something like 100 hours. I went, oh my gosh, are you kidding me? Really?
That's right. That's why we ask you to keep up with your hours. So when they say, how many times have you seen the kids? You can say, well, you pull out your little sheet and say, well, I saw them this many times. I've spent, 2,000 hours on the case. Not really. Not really.
Hey, that'd be great, I guess. So I get the call, back to my role, and I'll get through it. You just holler, just wave a red flag.
I will, because actually we got about 5 minutes, and we got to let Susan talk about her county, and we've got a CASA panel coming at 7:15.
Okay. So I get the call that the referral is, or that the case is coming to me. Look at the affidavit, we file a petition, we have the adversary shortly after that. If the kid is then, if the department maintains temporary managed conservatorship, we start setting it for various hearings. They used to have different names now. It's permanency hearing, before final, permanency hearing, after final. First hearing is status hearing where service plan comes in, then you have the initial permanency, then you have multiple permanencies, and then if the department remains the permanent managing conservator after the case is done, you have permanency hearings after final order. Names aren't all that important, I will tell you from a lawyer standpoint, we all know what the different standard, different burden that the judge is looking for. For instance, at the adversary, the question is endangerment and best interest. The question at the status hearing is, what are the contents of the service plan? Have the parents seen them? Have the parents reviewed them? What are they? One of the laundry list of terminating parental rights, one of the things is the parents failed to follow the provisions of a court order that would have allowed them to have the children returned. Well, when we have the service plan filed, that order from that day says the court adopts the service plan. So that's the order that they got to follow, and if they don't follow that, we may have an element now to prove for termination. And then every permanency hearing we have after that, the order goes back and confirms and adopts the service plan. Do that so that we have that ground if we need that ground. Then all of those hearings, though, what I'm typically asking the witnesses is, the first question is, what are the ages of the kids and what type of placements are they in a placement? So the worker will tell me that, and then I will say, how are they doing? And we can't lose sight of that. We got these little goofy elements, but we can't lose sight of the fact this is set up so the judge can be aware of what's happening with this child throughout this case. So, and our judge keeps docket sheets and he makes notes and he returns to court with his notes from last time. Some judges don't necessarily do that, so it's kind of a big deal. Because then he has memory of what happened before. It would stink if he didn't. But anyway, so I ask how the kids are doing. Then I go through the elements of the things that we're looking for, which are typically either has a service plan been filed and what are the contents if it's early on, or if we're not so early on, how are the parents doing on the service plan? And so then the worker will update the judge as to how the parents are doing. And the judge can see a train wreck coming. They're not doing anything, they're just positive, blah, blah. So he can see where we're going and he can start getting prepared for whether it's going to be a trial or not, whether it's going to be a bench trial or it's going to be a jury trial. One of the questions is whether at that point too, at some point in the middle of the case, oftentimes the judge is now beginning to consider whether he really needs to think hard about appointing the parents' lawyers. Now that's a question that in Grimes County is an interesting question. I won't get into the real details of it, but the judge oftentimes on the front end doesn't appoint a lawyer to the parents. And he will make sure they're in opposition.
That's in your county.
I
I
was
have
gonna
one
say-
judge that
Yeah.
does from day one when I file the petition.
Right. Okay.
Burleson and
Yeah,
Brazos,
yeah,
they
that's
get
in
attorneys
Grimes.
at day one.
It's in Grimes.
Well,
And
one
so-
judge, the other one you don't.
Well, I will tell you this, and forgive me for saying it, it's probably for budgetary reasons. It's because the county is paying the bill. And and parents are only entitled to an appointment if they're in opposition to the petition and they're indigent. The judge quizzes them about whether they're really in opposition, and by the time folks have talked to parents in the hallway and whatnot, look, the department's just going to be managing this case for a while, get you on your feet, you do the things on the plan, and then potentially kids could go back to you. And so when the judge gets them in front of the bench, are you sure you're in opposition to the petition? Are you sure? I don't hear you saying you're in opposition. So there's that gray area, but in all honesty, they got to have an attorney for a trial. The problem is sometimes it leaves the appointment to too close to the trial where the lawyer is saying, Judge, I don't have enough time. You appointed me and the trial's 10 days away. So anyway, so the hearings, I ask the same types of questions on permanency. As is progression of the trial, we will usually, if it's a case that's a close call, we'll go to mediation, see if we can work something out. If it's not a close call, it's one where we are in our position, entrenched in our position, and it is termination, we'll start to extol the benefits that the child will receive if there's a termination. If you can see the parents working the plan, you're really hopeful that it's going to be returned. I usually ask at the end of almost every hearing of the caseworker, what's the permanency goal? And the judge doesn't want the parents to be surprised that at the last hearing before the trial, you change the goal. The judge wants to know that the goal is staying consistent. So oftentimes you'll hear family reunification, which means back to the parents or one or the other parent. But sometimes you will hear that the goal is termination, adoption by a relative, adoption by fictive kin, adoption, or maybe just foster care. I mean, that's horrible when that's the circumstance. But I usually ask for the permanency goal and whether there's a concurrent goal, kind of a backup goal if that thing doesn't work. I want everybody to know where we're headed. If you haven't heard that before that hearing, you will hear at that hearing what the department thinks. Obviously, you have the right to ask that same question to the department caseworker and see what the department thinks about where this is going. I see my time is up. I'm going to say to you, the thing I kind of started with here is keep your eyes open. What you do is very important. The judge says that many times, and I know that he's sincere, that he relies upon what CASA has to say. He really appreciates what CASA has to say. And it has not always been the case that there were enough CASA workers in Grimes County or that could come to Grimes County or take cases from Grimes County. And there have been some that we pick and choose and whatnot. Recently, we've started having some, I think, almost every case. And that's awesome. It's great. I mean, especially if I'm telling you, if you're not in that place, a lawyer's going to be in that place, surely you can do better than a lawyer. All right.
All right, thank you, Mr. Fultz.
Okay,
Mr. Fultz
you
drove
bet.
from Houston
Thank you.
Come on, Susan. This is Susan Deskey. She's the county attorney in Burleson County. We're so glad to have her. How long have you been county attorney?
January.
Since January. So we're really happy that she's here. And she's going to talk to you not only about how her county works, but let's talk a little bit about the attorney ad litem, but
And I'll try to talk as
Yeah.
fast as I can.
that's okay. And I'm sorry we're so behind.
However, Mr. Fultz and I have the same job in the same state in different counties and have totally different things going on. For one thing, our judges, we have 2 district court judges that travel a 4-county circuit. They do Burleson, Lee, Washington, and Bastrop County. So when we have our dockets, we're in there because the judges are there once a week. You've got felons being convicted, you've got plea bargains going on, we've got divorce cases going on, sometimes I got protective orders going on, and then we're gonna throw CPS into the mix. But one of the things they have done is they've started moving our CPS dockets to 1:30 in the afternoon, which worked good for a couple of months, but now they're moving some felonies over to the afternoon too, because they're getting busy. So the experience is very different than his smaller courtroom, more intimate. The judge is only focused on that. So sometimes when we get into court, they're gonna let us ramble a little bit, and other times, no, we're moving. Also in my county, CASA is not a witness. However, they will read your court reports, okay? But on the regular hearings, generally, you're not asked, what do you think? Or what is this? Because the judge will take the time to read your reports. And so when occasionally a counsel will go, Judge, they will go, I know, I read that. Also, my 2 district court judges are both pretty formal. I mean, they've been judges for quite a while, so courtroom decorum and dress is very important. If you want to be taken as a professional, you do not have to wear a suit. However, please don't wear flip-flops and a short skirt, okay? Because if you want to be taken as professional, they expect you to dress professional. The lady judge is a little more warm and fuzzy. You can get by with a little more stuff with her. However, the man judge was a formal litigator, and he knows his civil stuff and actually appealed some CPS terminations in his day and age. But that's my test. When I get a new case, I'm sorry I was late today, because we're getting a new Burleson County case. I was working on the paperwork on it beforehand.
That's all right.
So, I use him as my standard. When I get a new case, I'm reading the affidavit going, what's Campbell gonna say? Okay, because he's the tougher one. When I'm taking a contested hearing, I'm thinking, because I get by with a little bit more with Corbett, right? However, because you go, oh, but Campbell, no, he's just a very plain and by the book, and he knows his law, and that's not a problem. You know what you're dealing with, okay? So, however, okay, so I was surprised when I started Burleson County because I was sworn in on January 1st. I started on January 3rd, and 4 days later, I was in a half-day bench trial termination on a dad. So since that time, I've had 4 trials, I've got 2 more set this year, and at the time I thought, my God, what happened? The biggest problem with Burleson County, well, the 2 biggest are domestic violence and meth, and I'm sorry, you can't usually fix meth in a year, okay? People that have long-term methamphetamine addiction, it's really, really hard for those parents to turn those around. It'll take them maybe close to the year before they even realize, oops. But I am happy because Judge Campbell now, he is the one that on day one, because so many go to trial anyway, will appoint attorneys. That's another thing. I was going over the affidavit, I was fixing it and changing a little bit in the petition, but he also wants me to file orders appointing for the mom and the dad on every single case on day one. And I think we're getting actually better results from that, because these people have a representative that they can trust, that is their representative from day one. Because a lot of times we're dealing with distrust, everybody in the room is against me, you know, and so it's hard to get people to do change when their mind is already shut off. So I think it's gonna help a little bit. However, I'm not happy with the trial that I have to terminate, even though it needs to be terminated, the week before Christmas, because that's just a hard time to sell to people, hey, let's cut mom off forever. But it needs to be terminated, and the reason for that is the lady judge has decided she's personally gonna watch this trial. And so that's the only time we could get it on her docket, which is why the defense attorney put it as a jury. So, because we know how that's gonna go, if it's just up to her. So in Burleson, I mean, the judges are great, they're going to pay attention, like I said, they're going to read your, and if they have a specific question from your report, they're gonna ask you. I see you wrote this down, what did you mean by this? But on our regular hearings, CASA does not testify. However, when I do go to trial, you are a witness, as long as you're comfortable with it. If you are not, you can work with your supervisor and I'll use them instead. I've had them testify as a fact witness because they actually saw visits, they've seen these things, things like that. And I also usually have them testify last because they wrap up my best interests. Okay? Legally, I have to get a grounds that they either did or didn't do one of these things or more. Generally, you try to get more within the law. If I hit that, I still have to have it in the best interest of the child. You know, sometimes parents aren't the best parents, but it's not necessarily in your best interest. Melissa and I actually had a phone conference, and I'm sorry I haven't had time to call Chantel today, that we have one that's set for trial in October where there is a baby, but the placement will not get any benefits, so they don't want termination. But we have the 17-year-old that Melissa wanted to terminate, but the kid didn't want it. So I had to have a conversation with her that I can't, while I have grounds and it's best interest, I got a 17-year-old that didn't want it. So we're not moving forward on termination on that one because it's not the right outcome. Just because you can, thank you, doesn't mean you should. Okay? And that's just case by case. Out of doing the hundreds of cases over 15 years, I've never had 2 the same. I've worked across 7 counties. I worked with the big massive thing in West Texas years ago. I had 2 ad litem cases out there. Excuse me. And I've never had 2 exactly the same. So you have to go into these with, you can't look at the report and go, oh, it's a methanol. No, there's a whole bunch more going on. Okay? So, Burleson County, you're gonna have to work hard. If you're in Burleson, you're gonna have a good chance of going to trial. So that's something to talk with your supervisors about. If you're not gonna be comfortable with that. Also, like I said, a lot of ours are domestic violence cases. So if you are uncomfortable with that, please let your supervisors know that, hey, I don't think I can work these kind of cases, because there's nothing wrong with that. There are certain kind of cases I don't like to touch. I mean, we all have those things that are not within our comfort zone. And while we have to step out a little bit, there's nothing wrong with saying I can't, okay? Now, excuse me. sorry. Okay. Now, jumping back to my 15 years previously, I've worked with, let's see, the youngest child I ever got was 4 hours old. I got appointed on because the sister was already in care and mom tried to sneak to the next county and have the baby and it didn't work. And then I had a 17-and-a-half-year-old was the oldest I got appointed on. And again, there's never been any two the same, ever. But one thing I can say is CASA can make a difference, okay? Recently, when I took office, I'm not allowed to do CPS stuff anymore, except I can do adoptions, because they're not contested. So it was with a heavy heart, because I had some kids 5 and 7 years that I was the attorney ad litem. And do you know, I looked at those, and the one, especially the 7-year-old, this was out of Brenham, the CASA and I were the only two she had had her entire CPS life. We counted 7 caseworkers, 2 supervisors, I mean, you know, throughout the years. And bless her heart, now, I'm not saying you're gonna get a 7-year sentence on your case. And occasionally you luck out and you get the newborn baby that grandma swoops in and they're all so happy and mom and dad relinquish and you're, but those are rare. You know, just warning you. And, you know, I've dealt with children that have been trafficked, that have been sexually abused. I've had children that pick up juvenile charges in the middle of their CPS case. So while we're keeping them safe, they're also committing crimes. So, you know, it just happens, okay? Because of what they were brought up around. It's not surprising. I've had children with mental health issues. I've had children with drug addictions. I've had children perpetrate on other children. That's interesting. So they're not only a victim, they're also a perpetrator, so we have companion cases. So that's, you know, and yet no two are ever the same. But that's why you guys are so important, okay? Because you are the reasonable, sane, non-legal voice standing in the room, okay? You have no other agenda other than to stand up and say, this is what I think should happen. I've had CASA strongly advocate for parents against CPS. CPS didn't want to, and they're like, no, this is not the right outcome. I've had it go the other way as well, like Melissa talked about. But for the most part, most of the CASAs I've dealt with are looking to keep the families. Okay, now family can be Aunt Sally, it could be mom. We seen a few years ago, we had all these cases that daddies came out of the woodwork that hadn't seen their kids in years. We had all of them in a row. They were, I haven't seen my kids in 5 years. It's like, well, yeah, how bad did you want them? But you know, well, no, that was the immediate thought. But then come to find out, no, the mom's just been moving a lot, and they didn't know, and they get stepped up. They took classes, and they took the kids, and they're raising them, and the kids are doing great. So you got to have an open mind. I've had great grandmothers adopt in their 80s. Now, that's a little bit of a hard sell with the judge sometimes. But, I mean, these are very active 80-year-olds. So keep an open mind, because what you feel is best for these children is a lot of times mom, a lot of times dad. I did an adoption for an older sibling that CPS, that was one of those CPS could not approve because she was 20. And under their rules, they have to be 21 to legally adopt. However, we got the court to overrule it, and then, you know, of course, CPS stood up there going, nudge, nudge, wink, wink, judge, sorry, you know, other than her being 20, we would approve this home study. So that's what we did, because it was their policy, and we got the right outcome. So you can be creative, you can get the right outcome. There's no cookie cutter answers.
I think Renee has a question.
Yes, ma'am.
Do you guys ever offer emancipation for the older kids?
Actually, I've done that for 2 kids when I represented them before.
Emancipation.
But I try to, the kids I represented, I try not to encourage that, because there's so many benefits if they will age out at 18 and stay in it, especially if you're close to that. But we have done it for a couple of them. It's just, they could lose some benefits by doing that. But sometimes it's the right answer. I mean, you know, we can usually get to where we need to get.
Yeah.
But it's just, and, yes, ma'am.
Are there, can there be open adoptions, like a foster family who has adopted
Yeah, well,
not relative?
under Texas law, and different attorneys have different opinions. My personal opinion has always been there is nothing legally enforceable in an open adoption. That is not something we can contract and that can be legally enforceable. However, I've had it happen a lot, and I've had very few of them that didn't follow through. And I've had everything from, one opened up a blog that gave the parents a password, like they didn't wanna see the kid, you know, all that, but they, and every year they'll post a picture of little Johnny in his baseball uniform, of course, they'll cut out what school it is and stuff, you know. And so that the parents can log in and see pictures of things, all the way up to sort of adopted mom too. So, you know, mom comes over for Christmas and, you know, those kind of things. So, but personally, I'm not sure that it's legally enforceable, but, I do believe that so many children I've seen, no matter how bad those parents are, at 18, they're out the door back to mom and dad, or mom and dad. And so if you can keep any of that bond together, they're gonna probably do it anyway. So, anyway, any other questions? I'll let y'all get to the next people. I hope to see y'all in Burleson County. I wasn't meaning to chase you off, but I was trying to kind of give you a reasonable that John's situation is very, very different than what happens in my town.
Well, you have increased our appointments in Burleson County. Before we weren't being appointed to all cases, they were selecting them, but love Susan, she loves CASA.
Well, you have enough volunteers.
That's right.
And, you know, love you guys, hate you guys, you're, you know, you play a very important role, because as the lawyers are all standing up there arguing the legal aspects of stuff, you guys are the voices going, hey, this isn't right.
Thank you
Right.
very much for, oh wait, we have friends popping in to help. All my CASAs are here for the panel, but they've been sitting since 5:30, so if we could take 5 minutes for everybody to take a break, that would be great.
Outside door is locked.
Because the probation just called me and said, well, there was some man on the third. Yeah, how did you get in the third floor?
I couldn't. You can
So
get
you
up to
were-
the lobby of the third. And because that's where the sign says, oh, probation, third floor. So I went to the third floor, but I didn't know if she told me what floor.
Okay, so her officer didn't tell her the whole thing.
No,
Okay.
so I banged on the door and she came to the door and she just kind of said, where's your gun or whatever.
Well, thanks.
I would like to ask you a question. Yes, sir.
I'm gonna put the chairs up there, y'all can be in front. I'm sorry, Myra.
Which courtroom?
Yes, thank you. No, we're good.
How are you?
I'm sorry.
Excuse me, thanks.
Yeah, so his fault.
Coming
Yeah,
is so helpful.
I didn't understand what was just curious what happened, what was going on there. I did the
Time to shout out on something, right?
two kids actually. But, we were going to meet that day to do the advocacy. Well, no, what they said was that mom was going to see her birth certificate. And they said that she wasn't supposed to get out until November. She might get out sooner. So I said, we'll go ahead and put it off. Before they told me. I sat there waiting. Yeah, but they had already known. Yeah, I mean, and I guess, does that have? Yes, it's in Brandon. I like John. John makes sure everybody knows, and I think values are old. But they crank the brewery. My impression is that the people we've heard from over the last couple of years, they say they do, they give lip service to it, deep down, they selectively, you know, we can be a pain in the ass. Raise questions, in all fairness, I mean, keep this in mind, for 30 kids, whatever, we've got, so we're more,
Don't get him sit up here with the,
it's slow down the process, they're attorneys, you know, they've got their case, their blah, 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 and you know, as a nation, you get full
okay, good.
well, you get the bleeding heart, you have the whatever, distracted. They're ready to get up, it's going to business, that means he's like, John, I like John, yeah. So I've done.
Yeah, I knew she was.
The judge there told too, he's like 115 years old. His primary goal, he'll tell you about, he told us about the clips, he tells us about defensive driving. Because once he gets past noon, he gets per diem. So I guarantee you, it's gotta go to noon. So.
She sent it.
One of my four supervisors. On the same case. How you doing?
As soon as Maddie gets back, we'll get started. Might have to sit up front with the people who are, you know, important to the class. Maddie, come in. You have a seat up front. What did I do with her?